Welcome to the Republican Professor. I'm my own host, Dr. Lucas J. Mather, and I'm outside today. You might be able to hear the waterfall here. I'll give you a little bit of a preview of the pool. The pool light is on. We're in the Bostock Dissents, whether the Civil Rights Act of 1964 covers so-called transgender, and we're in the position of the Republican dissents. There were no Democrat dissents, saying that the court got it wrong. What's interesting about this case, Bostock versus Clayton County, Georgia, is that there were two Republicans in the majority opinion, including a Trump appointee, Neil Gorsuch, and a Bush appointee, Roberts, Chief Justice Roberts. And we've gone through the entire majority opinion, and I've offered my criticism of that. I may have a few French fries, FYI. But I'll try not to be too annoying about it. I'm going to have a cigar too, so we'll I am having some whiskey. It's a Wolcott Kentucky bourbon, not a paid sponsor. If you are following along so far, what you're going to get out of this is a comprehensive look at whether the civil rights agenda of 1964 also covers the contemporary agenda of the Democratic Party. I've been critical the entire time, and we're going to continue in the criticism tonight. I'm in SoCal. The sun just set. Just went on a walk with my wife, watching the sunset. First things first, got to spend time with your wife and listen to her and her problems. And now I'm, after doing church admin all day, I'm doing this, okay? So I have it printed out. I've gone through this with a comb and I wish I could say it was the comb that my Uncle Ray gave me, but that's not the case. The comb my Uncle Ray gave me was for my birthday, and I had actually at the time wished it was a pocket knife. No, it's not the same comb, but I'm going to share my screen. Feel free to call me Sharon.
You always say that.
Yes, I do. How do you get here? You go to Google Scholar. You go to federal courts, case law, Bostock versus Clayton County, 590 U.S. 644. Now, that's not the pagination that this is using on Google Scholar. I criticized this before. It's using a different pagination. But to get there, to follow along, you just search "so ordered," and it'll come up. See? We're in Justice Alito's dissent, with whom Justice Thomas joins. There's only one word for what the court has done today: legislation. Now, right out of the box here, you're getting a constitutional objection. How is it a constitutional objection? Anybody know? Raise your hand if you know. Yes, in the back.
Because it has to do with separation of powers.
Develop that a little bit.
Well, in Article 3, the Constitution creates the court, and the court has the judicial power, but in Article 1, the Constitution creates the Congress, which has the...
Take your time. I don't want to rush you.
Has the legislative powers herein granted.
Very good. That's the correct answer. Right away, they don't even wait. Boom. Constitutional problem. Right here. The court has overstepped its constitutional bound. That's why this is going to be in the Supreme Court. Sorry, that's why this is going to be on YouTube. It's going to be in the constitutional law listing as well as in the statutory construction listing. Yes, those go together sometimes. There's only one word for what the court has done today: legislation. The document that the court releases is in the form of a judicial opinion interpreting a statute, but that is deceptive. Title VII of the Civil Rights Act of 1964 prohibits employment discrimination on any of 5 specified grounds. We're on page 1755 of the Supreme Court Reporter. See that? That's not on the U.S. reports. Ignore this part going across the top. It says U.S. reports. That's not the pagination that Google's giving you for some reason. Well, neither sexual orientation nor gender identity appears on that list. For the past 45 years, bills have been introduced in Congress to add sexual orientation to the list, and in recent years, bills have included, quote, gender identity as well, but to date, none has passed both houses. All right. How are you liking this so far? I like it. We got an Oliva 3. This is not a paid sponsor, but I'm going to light it up because I'm enjoying the Dissents myself. Oh, yeah, my T-shirt. I'm glad you asked. Sure, I'll show you the T-shirt. Gunfighter Tactical. Gunfighter Tactical. 10 years. They had to close down due to harassment from the California DOJ. Sadly. And Biden. But, yeah. Let me show you. Let me show you what I got here. See if I can change my video effects here. All right. See that? So I'm having a cigar and we're enjoying a little bit of a breeze here in SoCal. It's a nice October evening. I'm going to go back to my prior just because, well, every episode has been done. I want to keep the streak going. All right, so we're going to do some discussion if you want as well. That never the twain shall meet on this case. The two sides that the Republicans are on, they're on vastly different sides here. One side says the text of the 60-year-old Civil Rights Act is, such that it covers contemporary redefinitions of sex and gender instigated by the Democratic Party in their desperate attempts to hold on to power over business and over churches and synagogues and mosques, and to regulate the hell out of small business, which is their fantasy. The other side is saying no. 1964 Civil Rights Act does not reach the contemporary fascination with pronouns and trying to reinvent your gender and sex. And they're also saying it doesn't reach attempts to have special privilege based on sexual orientation as well. So let's go. Let's continue. It's a wonderful fall night, wonderful autumn night. We're going to continue. You have an enormous project on your hands. What do you think about this? Last year, the House of Representatives passed a bill that would amend Title VII by defining sex discrimination to include both sexual orientation and gender identity. That was the H.R. 5, 2019. But the bill has stalled in the Senate. An alternative bill, H.R. 5331, geez, that's the number of bills that are passed, 5331. Or sorry, not passed, but offered. Would add similar prohibitions but contain provisions to protect religious liberty. This bill remains before a House subcommittee. Because no such amendment of Title VII has been enacted in accordance with the requirements of the Constitution, passage in both houses and presentment to the President, well, Title VII's prohibition of discrimination because of sex still means what it has always meant. But the court is not deterred by these constitutional niceties. They're talking about the majority opinion, right? They're saying the majority opinion got it wrong. Gorsuch got it wrong. He's agreeing with me, right? That's what I've been saying for all these episodes so far. See the gender playlist in the U-Boob. The court is not deterred by these constitutional niceties, usurping the constitutional authority of the other branches. The court has essentially taken H.R. 5's provision on employment discrimination and issued it under the guise of statutory interpretation. A more brazen abuse of authority to interpret statutes is hard to recall. Wow. The court tries to convince readers that it is merely enforcing the terms of the statute, but that is preposterous. Even as understood today, the concept of discrimination because of sex is different from discrimination because of sexual orientation or gender identity. And in any event, our duty is to interpret statutory terms to mean what they conveyed to a reasonable people at the time they were written. Quoting Scalia and Garner, Reading Law Interpretation of Legal Text, 2012. Page 16. If every single living American had been surveyed in 1964, it would have been hard to find any who thought that discrimination because of sex meant discrimination because of sexual orientation. Not to mention gender identity, a concept that was essentially unknown at the time, and I would say it's still unknown. Alito, it's still unknown. Most people don't know what you're talking about when you say this kind of stuff. Most people have no idea what it means to redefine gender in terms of a feeling that you have at the moment or today or whatever. You know what I mean, Vern? The court attempts to pass off its decision as the inevitable product of a textual school of statutory interpretation championed by our late colleague, Justice Scalia. But no one should be fooled. The court's opinion is like a pirate ship. It sails under a textualist flag, but what it really represents is a theory of statutory interpretation that Justice Scalia excoriated. We're on page 1756 of the Supreme Court Reporter. The theory that courts should update old statutes so that they better reflect the current values of society. See Scalia, Matter of Interpretation, 1997, page 22. That's true. I had to read that book when I was in graduate school. My first, well, I was about to say my first, that's not right. Well, it was a judicial review and the Constitution course I took with Michael Ullman. We had to read that book. Summer of 2010. Great class. The time of my life. If the court finds it inappropriate to adopt this theory, it should own up to what it's doing. Amen. Amen, Alito. This is Justice Alito writing in dissent, joined by Clarence Thomas. Thomas, a Bush Senior appointee. Alito, a Bush Junior appointee. This is before Amy Coney Barrett came on. Remember, she came on late 2020 after a couple months after Ginsburg had died. Ginsburg is still alive at this point. Barely, but she's alive. Many will applaud today's decision because they agree on policy grounds with the court's updating of Title VII, but the question in these cases is not whether discrimination because of sexual orientation or gender identity should be outlawed. The question is whether Congress did that in 1964. It indisputably did not. Damn, son. How are you guys doing? I think this might be my favorite cigar, at least right now. I have changed my mind from time to time on this, but the Oliva 3, it's a pretty stick. It's pleasant. They come in different sizes. It's pretty high quality. It's a little bit windy, and normally I'm a little bit nervous about with these lower quality ones. They don't burn well in the wind. This is fine. It's like a Ford F-350 diesel cutting through. I'm trying to give you guys a sense that you can read these things and understand them yourself. You don't have to be a lawyer. And do I have to be a lawyer? My mentor, Michael Ullman, talked me out of going to law school in the summer of 2007. Yeah, I'm going to have a French fry. French fries are from John's Place in Brea, California. Walking distance from my current location, which is at my mentor's house, Dr. Doug Guyvett, epistemologist, taught my epistemology courses philosophy of religion courses, religious epistemology. The dude is dialed in, man. Great mentor. Been house sitting for him for 22 years, something like that. He's had this pool the whole time and taken very good care of it. Very good care of their backyard. They've done a wonderful job. But what I was going to say about Michael Ullman is that my mentor in graduate school, he died 6 years ago, almost exactly. Michael Ullman was my mentor in constitutional law and statutory construction, admin law. He convinced me not to go to law school. Catholic fella, Republican. To say he was a Republican was to understate it. He'd work for Ford. Okay, don't judge. Don't judge. Technically a Republican. Actually, Ford, we did a whole episode on Ford with Alex Heineman. Look it up. That was spring of 2023. He's an expert on Ford, wrote his dissertation on Ford. Ullman worked with Ford high up in the Justice Department with someone named Antonin Scalia. Which Antonin Scalia are you talking about? Yeah, same one. Same one referred to right here. They were both assistant attorney generals in Ford's Justice Department. Senate confirmed. Yeah, high up. I think he was assistant secretary for Ledge Affairs or something like that. I can't remember. When Ronald Reagan ran and won against Carter, thank God, Ullman came back into government after completing his Ph.D. at Claremont under Harry Jaffa. Okay. You following this? He'd already had a law degree. He was already an attorney. He had an LLB from University of Virginia. That's back in the 60s when they gave that degree instead of the JD. And Ullman was classically trained at Yale, went to a private school with a bunch of nuns where he had to learn Latin and logic and crap like that. Great books. Studied English literature and history at Yale for his undergrad. Went to LLB for Virginia. I ran into him at Claremont in 2007. He said, read A Nation Under Lawyers by Mary Ann Glendon. And we ended up talking for an hour. I did read the book, but the discussion we had for an hour was, he said, if you want to learn the truth about the law, study it as a PhD student. Don't study it. Don't go to law school. They're pumping out technicians. Roughly half of all attorneys lose in confrontation in court, right? I mean, if there's not a settlement, if there's a judicial determination, someone loses most of the time, right? In a final determination. I'm not talking about settlements, okay? There's a winner and a loser. Well, there's attorneys on both sides. Law school prepares you to be an advocate. Yeah, and when competition is really stiff, you're advocating for yourself as a professional. But at the end, someone wins and someone loses. That means about roughly half of the attorneys are wrong. If you want to get training that is not just how to be an advocate, which is slightly different than finding the truth. You want to find the truth. right? It's not exactly the same skill set as being an advocate. I'm not saying they're totally unrelated. I'm saying half of all attorneys in these disputes that are not settled in court, but determined by court, lose. Now, how do you know who's wrong? Is it the one that lost? Well, why would that be? Is it the one that won? How do you determine those things? So you want to get into that. You want to get into the philosophical issues, the historical issues. You want to study it as a Ph.D. student, so that's what I did. I owe a lot to Michael Ullman. He came in to work with President Reagan in the White House and was counsel for President Reagan. Pretty freaking cool, man. He was on the Bush transition team. He convinced Clarence Thomas to be a judge. Mentored Clarence Thomas in getting confirmed to the D.C. Circuit. Later, tapped to be dissenting with Alito right here. A. Roman numeral 1A. Title VII, as noted, prohibits discrimination because of sex. And in 1964, it was as clear could be, that this meant discrimination because of the genetic and anatomical characteristics that men and women have at the time of birth. Determined searching has not found a single dictionary from that time that defined sex to mean sexual orientation, gender identity, or, quote, transgender status, unquote. Very good. He put the quotation there. See, that's what I was doing. In all those dictionaries, the primary definition of sex was essentially the same as that in the then most recent edition of Webster's New International Dictionary. Quote, one of the two divisions of organisms formed on the distinction of male and female. And he's got four different references there. The court does not dispute that this is what sex means in Title VII, although it coyly suggests that there is at least some support for a different and potentially relevant definition. If that is so, it should be perfectly clear that the Title VII does not reach discrimination because of sexual orientation or gender identity. If sex in Title VII means biologically male or female, then discrimination because of sex means discrimination because the person in question is biologically male or biologically female, not because that person is sexually attracted to members of the same sex or identifies as a member of a particular gender. Let me go back here and mention something here that's important. What Alito has done here in fixing it at the time of birth is essentially take the issue of sex identification and do what I did when I was going through in the first episode where we covered Justice Gorsuch's opinion for the court. What we did there was note that in the list of protected categories, national origin is listed, and sex is most like national origin. Can you change your national origin? That's a serious question. Now, can you change your religion? It seems like you can. It's called conversion, right? Don't get into Calvinism and all that stuff. I mean, does God do it? I'm not. Can it change? It can change, right? Okay. Of course, because then if it couldn't change, nobody would be a Christian because nobody's born a Christian. Everybody starts out as a pagan. I brought an ashtray. I got to grab the ashtray real quick. So far, so good, right? Some of these protected categories are malleable, are mutable, they can change. National origin, can it change? Unless it's metaphysically possible to go back in time, the answer is no. What about veteran status? Can you change veteran status? Remember, trans means change. Transportation, change locations. Transform, change form. The term transgender implies changing gender as if it's metaphysically possible. So it leads to the question, and it even begs the question of whether that's possible. We're assuming it is possible, but that's not something that's in evidence here. It's highly contentious. Can you change veteran status? Well, whatever your status is could be bureaucratically changed without going back in time. Bureaucratic status changes all the time on government forms, depending on what bureaucrats say. You know? I mean, the underlying facts can't change unless you go back in time. But we're not talking about what's on some government form. We're talking about, when we talk about sex, we're talking about a fact about you, not how you feel. It never has been presented as a question of how you feel. That's a category mistake. It's changing the subject. Just like national origin has nothing to do with how I feel. I may not like my national origin. I may have a desire to lie about my national origin, to speak falsely about it. Or I could be mistaken about it and speak falsely about it. Maybe I was born in Cuba and my parents never wanted to tell me the truth about it, so they told me I was born in Florida. And so what the majority here has done is basically bless from the ceremonial august chamber of the Supreme Court people that are mistaken about this very issue, this category mistake, with tremendous confusion and cost. And possibly really disrupting the body politic. Can Congress fix it? Said it a million times. Yes, of course. But that doesn't mean they're able to practically, because they have other things going on. I mean, the government's not even open right now. It's October 22nd, 2025. As far as I know, it's not open. I mean, it is open, but you know what I mean. There's other things going on besides this. How then does the court claim to avoid that conclusion? Alito continues. The court tries to cloud the issue by spending many pages discussing matters that are beside the point. The court observes that a Title VII plaintiff need not show that, quote, sex, unquote, was the sole or primary motive. This is good. This is good stuff right here. I'm going to highlight this. The court observes that a Title VII plaintiff need not show that sex was the sole or primary motive for a challenged employment decision or its sole or primary cause. I made a huge deal of this causation issue. It's very unclear. I know the court, Gorsuch is just claiming that he's unpacking the precedent, but I didn't give him a pass on that, because when the precedent is muddy like this, you got to clarify. If it's not the sole motive, there could be other motives or causes, then I think you really do need to clarify, what if it's a very tiny cause or motive? What if it's 1%? And it says it might not even be the primary. So we're already saying it could be under 50%. Well, let's keep going. What about 30? What about 20%? What if it's 1%? That Title VII is limited to discrimination with respect to a list of specified action, hiring, firing, and that Title VII protects individual rights, not group rights. Okay. All that is true, but so what? Now, he's saying so what? So he's saying that the precedent is fine. I'm saying you got to clean up the precedent on the causation issue. But he's saying so what? In cases like those before us, Alito says, joined by Thomas, a plaintiff must show that sex was a motivating factor in the challenged employment action. So the question we must decide comes down to this. If an employee, an individual employee or an applicant for employment shows that his sexual orientation or gender identity was a motivating factor in hiring or discharge decision, for example, is that enough to establish that the employer discriminated because of sex? Or to put the same question in different terms, if an employer takes an employment action solely because of a sexual orientation or gender identity of an employee or applicant, has that employer necessarily discriminated because of biological sex? The answer to those questions must be no, unless discrimination because of sexual orientation or gender identity inherently constitutes discrimination because of sex. The court attempts to prove that point, and it argues not merely that the terms of Title VII can be interpreted that way, but that they cannot reasonably be interpreted any other way. According to the court, the text is unambiguous. The arrogance of this argument is breathtaking. Wow. Wow. As I will show, there is not a shred of evidence that any member of Congress interpreted the statutory text that way when Title VII was enacted. But the court apparently thinks that this was because the members were not smart enough to realize what its language means. The court seemingly has the same opinion about our colleagues on the Court of Appeals, because until 2017, every single Court of Appeals to consider the question interpreted Title VII's prohibition against sex discrimination to mean discrimination on the basis of biological sex. And for good measure, the court's conclusion that Title VII unambiguously reaches discrimination on the basis of sexual orientation and gender identity necessarily means that the EEOC failed to see the obvious for the first 48 years after Title VII became law. Wow. Something weird is going on here. By the way, the guy that's signing on to this, Justice Thomas, he was chairman of the EEOC under Reagan. It's a job that he had when my mentor, my constitutional law mentor, Michael Uhlman, was convincing him to become a federal judge. Pretty freaking cool, man. Day in and day out, the commission enforced Title VII, but did not grasp what discrimination because of sex unambiguously means. The court's argument is not only arrogant, it is wrong. It fails on its own terms. Okay, watch this here. Sex, sexual orientation, and gender identity are different concepts, as the court concedes. Homosexuality and transgender status are distinct concepts from sex, quoting the majority. And neither sexual orientation nor gender identity is tied to either of the two biological sexes. Both men and women may be attracted to members of the opposite sex. And notice the word opposite sex has meaning there. Why is it that has meaning? Because there's only two. Members of the same sex or members of both sexes, and individuals who are born with the genes and organs of biological sex may identify with a different gender. Okay. Maybe. They identify. But what's identify mean? Say? Can they lie about it? Can they lie about what gender they are? Using slightly different terms, the court asserts again and again that discrimination because of sexual orientation or gender identity inherently or necessarily entails discrimination because of sex. Here he's giving the receipts, as people say. The receipts. Here's the receipts. Here's the quotes. But, and there's only one T, so don't get too excited, repetition of an assertion does not make it so, and the court's repeated assertion is demonstrably untrue. Contrary to the court's contention, discrimination because of sexual orientation or gender identity does not in and of itself entail discrimination because of sex. we can see this because it is quite possible for an employer to discriminate on those grounds without taking the sex of the individual applicant or employee into account. Tell us what you mean, Alito. An employer can have a policy that says we do not hire gays, lesbians, or transgender individuals. And an employer can implement this policy without paying any attention to or even knowing the biological sex of gay, lesbian, or transgender applicants. In fact, at the time of the enactment of Title VII, the United States military had a blanket policy of refusing to enlist gays. I would say, Alito, I think you want to use the word homosexual because I was happy when I joined the military. They did ask me if I was homosexual or not, and I responded that I was happy. And they said, come on board. So they didn't ask me if I was gay. They asked me if I was homosexual. You know what I mean, Alito? So I'm going to change it for him to homosexual. The United States military had a blanket policy of refusing to enlist homosexuals. He says, or lesbians, but there's not a separate question. It just said homosexual. That's all it said. I have a copy of it. I signed it under Bush Sr. And under this policy, for years thereafter, applicants for enlistment were required to complete a form that asked whether they were homosexual. Yeah, that's what I just said. Where is homosexual? Why are we avoiding this term? It's a perfectly useful term. It's just as useful as the term heterosexual or bisexual. Come on, guys. Come on. Let's quit giving in to the Democratic Party. Their little strategies for election or whatever they're doing, whatever kind of strategies they have. You don't need to constantly bow to what they want to do. You know what I mean? You know what I mean? Okay. Let's keep going. I'm having fun. Are you? Okay. At oral argument, the attorney representing the employees, a prominent professor of constitutional law, was asked if there would be a discrimination because of sex if an employer with a blanket policy against hiring gays, lesbians, again, homosexuals. There's not different categories of homosexual. It's just homosexual. And transgender individuals, so-called, implemented that policy without knowing the biological sex of any job applicants. Her candid answer was that this would not be sex discrimination, and she was right. Who is this person? It's clicky little wiki. That was... Oh, it doesn't say. Footnote 10. The attorney's concession was necessary, but it is fatal to the court's interpretation, for if an employer discriminates against individual applicants or employees without even knowing whether they are male or female, it is impossible to argue that the employer intentionally discriminated because of sex. I'm going to highlight that for you. An employer cannot intentionally discriminate on the basis of a characteristic of which the employer has no knowledge. Interesting premise there. Seems legit. And if an employer does not violate Title VII by discriminating on the basis of sexual orientation or gender identity without knowing the sex of the affected individuals, there is no reason why the same employer could not lawfully implement the same policy, even if it knows the sex of the individuals. If the employer takes an adverse employment action for a perfectly legitimate reason, for example, because an employee stole company property, that action is not converted into sex discrimination simply because the employer knows the employee's sex. As explained, a disparate treatment case requires proof of intent that the employee's sex motivated the firing. In short, what this example shows is that discrimination because of sexual orientation or gender identity does not inherently or necessarily entail discrimination because of sex, and for that reason, the court's chief argument collapses. How are we doing? Let's catch our breath here. You're going to get the most benefit of this if you print this out and follow along. I cannot make you do anything. I can't make you do anything. So I'm not going to sit here and harp on you about this. If you want to do it, you can. You know what I'm talking about. Okay, we have about 3 more pages of A. And I think I'm going to stop here. Let you take a look. It's Wednesday, 22 October 2025. Let me know what kind of comments and questions you have for the Republican professor on this issue. Is Alito right? Did the court's chief argument, in his words, collapse? I think it does. Which brings up the question, though, what's motivating Gorsuch here? Why did the Republicans go over to the other side, Gorsuch and Roberts, on this issue? I don't know. I think they wanted to. They wanted to be the people that saved the day for a vulnerable community, but they just ended up making it worse. That's my interpretation of it. Yeah. All right, hold on a sec. I'm gonna call. I gotta call. I gotta make a call. I'll be right back. Actually, I'll just let you guys go. Thanks for joining me on the Republican Professor Podcast. I've been your host, Dr. Lucas J. Mather. We'll catch you next time, okay? God bless you guys. We'll continue with A next time. Take care. Today is 22 October 2025, years after Jesus. You know what? We didn't do a psalm and we didn't do streams in the desert. We'll do that next time.